Hello and welcome to the big picture. As the UPA government battles the opposition over the damaging CAG report which has stalled the functioning of the parliament all of this week, some good news emanated for it from the Supreme Court today. The recently reappointed Finance Minister Mr. P. Chidambaram, who has been under a shadow of suspicion in the 2G case, found huge relief as the apex court gave him a comprehensive clean chit while dismissing the petition of Dr. Subramaniam Swamy, who had sought to make Chidambaram as a co-accused with the former telecom minister A. Rajya. What does this mean to the ongoing case against A. Rajya and others today, while asking the question, what are the implications of Chidambaram's clean chit in the 2G? To discuss this, I have with me today Nilotpal Basu, CPIM Central Committee member and someone who has followed the entire 2G matter very closely. We will be joined soon by Mr. KTS Tulsi, a senior advocate of the Supreme Court. And here in the studio with me is Vinod Sharma, political editor, Hindustan Times. Welcome to all of you. Nilotpal, first coming to you. What is your first reaction to this? You know that this seems to be a very comprehensive clean chit to Mr. Chidambaram.
I don't understand. I have not seen the order, but
I have the order with me.
But it seems that what you are saying is comprehensive. Cannot be so comprehensive because all matters pertaining to the 2G spectrum scam is being examined by a joint parliamentary committee, and there I think the policy as well as the role of individuals who decided the whole issue in the manner that they did is being gone into. So I think no judgment, no order can be comprehensive enough to cover for everybody. Secondly, I think the trial court is going on with the criminal role of Rajya and possible accomplices that he might have been having in his criminal conduct. So I think we are aware that it was both the then finance minister and the telecom minister who were jointly responsible for fixing the spectrum prices. And now by the government's admission itself, the prices that has been, float prices that has been fixed will actually render to the exchequer something in the tune of what
Nilotpal, I want to just read two paragraphs of the judgment. It says, I am quoting from the Supreme Court judgments of today. P. Chidambaram and A. Rajya met on 29/5/2008 and 12/6/2008 for resolving the then outstanding issues relating to the allocation and pricing of 2G and 3G spectrums. Meeting of two ministers would not by itself be sufficient to infer the existence of a conspiracy. Even before those meetings, as instructed by the finance minister, the finance secretary and telecom secretary had already met on 24/4/2008, had agreed that it might not be possible to charge operators already having allocation up to 6.2 megahertz, and the principle of equity and level playing field would require that the operators who get fresh allotment of spectrum up to 6.2 megahertz for GSM, too should not be charged for spectrum up to 6.2 megahertz for GSM. Therefore, the allegation that Sri P. Chidambaram had overruled his officers' views and had conspired with Sri A. Rajya is without any basis. So this is one of the paragraphs. The second paragraph I would like to read, just for your and the viewers' interest. Criminal conspiracy cannot be inferred on the mere fact that there were official discussions between the officer of the MOF and that of DOT and between the two ministers, which are all recorded. Suspicion, however strong, cannot take the place of legal proof, and the meeting between Sri P. Chidambaram and Sri A. Rajya would not by itself be sufficient to infer the existence of a criminal conspiracy so as to indict P. Chidambaram. It looks pretty comprehensive. I'll come back to you. Vinod, doesn't this look like a pretty comprehensive clean chit?
Well, of course, I mean, Mr. Chidambaram, as you said in your opening remarks, has got relief, and that the sword that was hanging over his head, the Damocles sword, is no longer there.
Vinod, sorry, I'll have to cut you here. We have Dr. Subramaniam Swamy, the petitioner in this case, on the phone line with us right now. Dr. Swamy, can you hear me?
Yes. Yes, I can hear.
Okay. I don't know whether you heard some of the part of the judgment which I was reading.
I heard what you read out.
Okay. Now, I'll just finish that paragraph. Petitioners submit that had the Minister of Finance and the Prime Minister intervened, the situation could have been avoided. That is, this is what you submitted. Could have been avoided, might be or might not be. A wrong judgment or an inaccurate or incorrect approach or poor management by itself, even after due deliberation between ministers or even the Prime Minister, by itself cannot be said to be a product of criminal conspiracy.
Yes.
Yes, Dr. Swamy.
It
looks like a comprehensive clean chit to Mr. P. Chidambaram.
It may look like a comprehensive clean chit to Mr. Chidambaram according to you, but the fact is that none of these three paragraphs appear anywhere in my petition. I don't know which petition this judge is talking about. That is why I plan to go on review. Let me summarize my case. The Section 13 of the Prevention of Corruption Act has three parts.
Right.
Part 1, where the person holding a public office is accused of accepting a bribe.
Right.
What is called as a pecuniary benefit. Part 2 talks about his entering into a conspiracy or misusing his position
Yes.
to benefit some people,
Yes.
including himself.
Right.
Part 3 says, in public office,
Yes.
he makes it possible for somebody to earn pecuniary benefits, which is not in the public interest.
Right.
I was on the third.
Right.
And that third, there is a Delhi High Court Division Bench judgment which says it does not require criminal conspiracy.
Right.
It does not require criminal intent.
Right.
It doesn't require mens rea.
Right.
It just requires that a person must be in public office, that you must prove that somebody benefited by his decision.
Absolutely.
And three, that it was not in the public interest.
Right.
Now, I have proved that Swan Telecom and Unitech got pecuniary benefits. My petition asking for cancellation of the licenses was agreed
Right.
by the Supreme Court,
Right.
saying that it was not in the public interest. So public interest, lack of public interest, I proved.
You
I
have not,
proved that somebody got benefit.
Dr. Swamy, I would like to, I'm sorry, I'd like to interrupt you here. I just want to read another part of this judgment. Since you're talking about Swan and Unitech,
Yes.
let me read just a small paragraph of the judgment.
Yeah.
It says, I just want to...
First, before you read, please accept what I said. You read my petition and show me where I have argued this.
Since you're talking of pecuniary interest through Swan and Unitech, I just want to say, want to read what the Supreme Court says in its order. We are of the considered, I'm quoting from the Supreme Court judgment, we are of the considered view that materials on record do not show that Sri P. Chidambaram had abused his position as a Minister of Finance or conspired or colluded with A. Rajya so as to fix low entry fee by non-visiting spectrum charges fixed in the year 2001. Nilotpal, coming back to you. Let me finish reading this particular paragraph. It says, no materials are also made available even for a prima facie conclusion that P. Chidambaram had deliberately allowed dilution of equity of the two companies, Swan and Unitech. No material is also available even prima facie to conclude that P. Chidambaram had abused his official position or used any corrupt or illegal means for obtaining any pecuniary advantage for himself or for any other persons, including A. Rajya. Nilotpal.
I think, Girish, first let me make this very clear that since you are going into the lengthy quotations from the Honorable Supreme Court's order, you will also allow me little more time to
you will have all the time to speak.
No, I don't need all the time.
Yes.
I would like also my very good friend Vinod Sharma to enlighten us.
Yes.
what I was talking about was it has never been our case because it is to the credit of the left parties, particularly that of CPIM, because we broke the scam.
Right.
I think my good friend Vinod Sharma will bear me out. We did that while we were supporting the UPA government in February 2007.
Nilotpal, I'm sorry. I think we have got Dr. Subramanian Swamy back on the phone line. Let me just finish with him. I'll come back to you.
Yeah.
Yes, Dr. Swamy.
Read.
Right. Dr. Swamy.
You want to read something about pecuniary benefits.
Yes, I'll just read the last material. This thing that no materials are also made available even for a prima facie conclusion that P. Chidambaram had deliberately allowed dilution of materials, dilution of equity of the two companies, Swan and Unitech. No material is also available even prima facie to conclude that P. Chidambaram had abused his official position or used any corrupt or illegal means for obtaining any pecuniary advantage for himself or any other persons, including Sri A. Rajya. Your argument just before your line got disconnected was that you have proved that there was a pecuniary advantage, and here the Supreme Court is saying that this has not been proved.
Please. No, wait a minute.
Okay.
You don't mix up things.
Okay.
It says that misused this position to benefit. I never said he misused this position.
You said he used this position.
Please read section part 3 of the section 13.
Right.
You should have a copy of the act before you.
Okay.
You read it. There is no talk of misuse. Misuse is in part 2.
Okay. No, but what is your contention?
I never referred to that.
What was your contention?
My contention is that Mr. Chidambaram made it possible for these companies to be able to sell it to foreign companies by which they earn pecuniary benefit. These companies earn pecuniary benefits is there in the CBI charge sheet.
Yes,
So
but linking it to...
The only question, please listen.
No, CBI charge...
Is whether Chidambaram misused his position or not.
No, sir, Mr. Dr. Swamy, CBI charge sheet, I agree with you what you are saying. But the important question is linking that with Mr. P. Chidambaram, which the Supreme Court says you cannot link.
I never linked. I said that the decision to allow share dilution led to these companies earning.
And here it says, as far as the share dilution is concerned, Chidambaram was not involved in that.
That's rubbish. The judgment doesn't say that. Please read that. Show me.
No.
Read it out.
Yes.
Where does it say that?
No materials are also made available even for a prima facie conclusion that P. Chidambaram had deliberately allowed dilution of equity of the two companies.
There again, please. The word deliberately is not there in my charge. That is in part 2 of the...
It's not in your charge, but the Supreme Court has concluded that there was no such thing.
The SupremeUrt has concluded everything which has got nothing to do with my case.
So your argument today is that the Supreme Court has not understood you.
It is there in my petition.
No. Is it your contention today that the Supreme Court order doesn't understand what you are trying to...
Today means what? It is there in my petition.
So you think that the Supreme Court has completely misread your petition?
They have not only misread it, they have read somebody else's petition.
Okay.
It has got nothing to do with my petition. That's why I'm going back in review.
Okay.
Maybe they mixed it up with Mr. Prashant Bhushan's petition. I don't know. But it's got nothing to do with my petition. My petition is very straightforward. As a public official, he made it possible for Mr. Swan and Unitech to earn, and this was not in the public interest.
Okay.
All three I approved.
Anyway, you will be going for a review, but please stay on with us. If you can keep the line on, please stay on with us. I'll come back to you. Nilotpal, sorry.
Please, as far as the pejorative words you use like comprehensive and all, doesn't apply to me.
No, that is all right. You can hold that thing. Let me go to Nilotpal Basu now. Nilotpal, sorry for interrupting at that point of time. You can complete what you were trying to say.
You see,
now and also I would like you to comment on what Dr. Subramanian Swamy is saying.
You see, that is precisely the point we had, that and for which I think there was a major confrontation in the parliament as well, that The court or the investigative agencies by themselves cannot go into every aspect of this 2G spectrum scam. I mean, courts will have to necessarily respond and limit itself to the points raised by the petitioners. So, every aspect of this very obnoxious exercise which was undertaken by the government at that point in time regarding 2G allocation cannot be covered by the courts and by the investigative agencies. And therefore, we were never into substantiating or vouchsafing for the contents or veracity of Mr. Swamy's petition. What I am saying that you see, the trial court is going into the criminal aspects of Rajya.
Right.
We don't know what criminal courts that criminal trial will yield eventually, because it is very unlikely that Mr. Rajya did what he did without clearances from the other players in the Union Council of Ministers. Ours is the cabinet system, and therefore one individual breached every regulatory oversight and every system to do what he did is little far-fetched in our opinion. And in any case, since it has been accepted that the 2G spectrum scam will be comprehensively studied by the Joint Parliamentary Committee created for this purpose, I think the final word about who did what and what was their role in this entire engineering of the obnoxious scam for which the country lost so much money, which is now comprehensively proved, has been said.
Okay, Vinod, we admit the fact what Nilotpal is saying, that there is a criminal case going on. Dr. Subramanian Swamy says that he will go in for review. He feels that the Supreme Court has misread his petition. It was not his petition on which they have given the
Not
judgment.
misread, read some other petition.
Some other petition. Yeah, okay. But the question now is, there was this huge shadow of suspicion on Mr. P. Chidambaram. You think after this he will be he will have a he will be looked at differently?
Well, first of all, I think as of today, what prevails is the Supreme Court judgment.
Yes.
Dr. Swamy wants to go in a review. He has all the right to go in a review. He says that the points that his prayers before the court were different, and the judgment of the court does not address his prayer.
Right.
That's his point.
Right.
And his point is that under the provisions of the Anti-Corruption Act, which he moved, he said that if some loss is caused to public exchequer by the decision of a minister, that itself is makes him culpable. Now that matter will have to be decided by the court. If his review is accepted, it will be heard in camera, if I am not wrong. Dr. Swamy can correct me if I am wrong. It will be held in camera and not in open court.
Right.
Reviews are held undertaken this way. But till that happens, until the court reviews his own decision or accepts Dr. Swamy's review prayer, this judgment stands.
Absolutely.
And we have to now discuss as to what implications does it have for the JPC's proceedings.
For the JPC, absolutely.
Because the last
Nilotpal
JPC,
is talking of JPC
last
also.
JPC, and Nilotpal can educate, the last JPC was a very stormy affair,
Right.
where they wanted the Prime Minister and the Finance Minister to present themselves before the committee,
Right.
For questioning and examination. Now, whether the opposition will persist with it in the light of the Supreme Court judgment, one has to wait and watch.
Absolutely.
I'd like to pose this question to Nilotpal Basu and ask him that whether that position of the opposition has weakened and the government's position against making these two depots strengthened for the time being, till the time the judgment is valid and there is no review of it. That is one question.
Yes.
The other question is that if this judgment sustains,
Right.
and I'm using this is because Dr. Swamy keeps on saying that he's going to go in for review.
Yes.
If this judgment sustains, then at least this government, which has painted itself in a corner for various reasons, will have some talking points.
Yes.
Or even on the Colgate. that our minister was wrongly sought to be implicated, that there were charges against them which couldn't be established in a court of law. They can use this to make political points, even on the Colgate scam.
Right.
So this is the situation as of now.
Okay.
This may not be a situation which may sustain for long, but as of today, this is the situation.
Okay, I think we have Mr. KTS Tulsi, a senior advocate in the Supreme Court, on the phone line. He has got stuck in a traffic jam after the following heavy rains in Delhi. Mr. Tulsi, can you hear me?
Yes, I can hear you.
Okay, Mr. Tulsi, I don't think you have heard what I have. Dr. Subramaniam Swamy also on the other phone line. Dr. Subramaniam Swamy's contention is that today's Supreme Court judgment is nothing to do with his petition. He says that his petition was not on the order, has not come on his petition. They have completely taken some other's petition and given the judgment on his petition.
No, I don't think so. I think the criminal law is extremely technical.
Right.
If you want a person to be summoned as an accused,
Right.
in a particular case,
Yes.
then you have to be able to satisfy the essential ingredients of that offense.
Yes.
And it's if Dr. Swamy says that he never argued that Mr. Chidambaram was part of the criminal conspiracy, that is by itself a good enough reason to reject the prayer for summoning him
to be a
answer these charges. There has to be reason to suspect.
Right.
That means that Dr. Swamy was not able to make out a reason to suspect that Mr. Chidambaram had committed any offense.
Mr. Tulsi, on this point, let me get Dr. Subramanian Swamy on this.
Yes.
Dr. Swamy, you heard what Mr. Tulsi said.
Well, I did hear. He's a highly respected lawyer and I respect him a lot. The fact of the matter is that Mr. Tulsi doesn't seem to be aware of a judgment of the division bench of the Delhi High Court in Nuru Ghosh versus the CBI, in which the matter was specifically posed to the bench by the single judge, Justice Muralidhar,
right.
who asked to be whether Section 13 bracket 1 bracket D part 3 requires mens rea or criminal conspiracy or criminal intent. And the division bench judgment headed by Justice Ravindra Bhatt categorically stated that as far as this part is concerned, a plain reading of the Act shows that you don't need criminal conspiracy, criminal intent or mens rea for the offense to take place.
Mr. Tulsi,
Yeah.
sorry, let me get Mr. Tulsi in. Mr. Tulsi, what is your reaction to this argument of Dr. Swamy?
Dr. Swamy is right, but that's a different issue. Question really is that any loss which is caused to the government cannot, all kinds of losses can't amount to an offense. It's a question that here is a government policy where it was decided that in the larger interest of economic growth,
right,
and for empowerment of the poorest and the people living in the remotest corners,
right,
it is more important to develop teledensity and provide this service of connectivity to the people rather than earn money. So it's not a question of loss; it's a question of policy. It's a question of priority.
I think, Mr. Tulsi, I think O.P. Saini, the special judge O.P. Saini, had made this point in his judgment earlier on this issue.
May I reply to this?
Yes, Dr. Swamy, please reply.
Yeah, well, Mr. Tulsi is giving the argument of the accused in the trial court, and he is, after all, defending them, so I don't blame him for that. But the fact of the matter is, it's got nothing to do with policy, it's got nothing to do with whether they should be auctioned or they should not be auctioned. The mere fact is that the share dilution that was permitted by Mr. Chidambaram, without, I'm not alleging any intent or malafide or misuse of post, nothing. That which he prevented, which I presented evidence of a note filed by Mr. Rajya himself, and his meeting with the Prime Minister, where it is very clearly shown that because of the stand he took, somebody benefited without public interest. The word is not that
Okay,
any
we
loss
will-
is there.
Dr.
Without
Swamy,
public interest,
right.
and that is what is the key.
Okay, Dr. Swamy, you're in any case, you're going in for a review petition. Let me get Nilotpal Basu in on this. Nilotpal, let us keep the intricacies of the legal arguments between these two people now. Now, so Vinod Sharma had raised a point. What will be the implication of this judgment on the JPC?
To understand
Okay.
that I don't want to expose myself to the privilege of the parliament. You see, it is very clear that the JPC has a very comprehensive terms of reference.
Right.
And both the judiciary and legislature are independent organs of the state.
Nilotpal, we are completely running out of time. I want you to answer my question, specific question. You as a former parliamentarian, you have been on many committees, you understand the system very well. Now, people who are demanding that Prime Minister Manmohan Singh and P. Chidambaram appear before the JPC, will they have a weaker case after this Supreme Court judgment?
I don't think so, because if the 2G spectrum has to be specifically understood by the committee, and if at any point in time the Prime Minister and the Finance Minister on record had a role to play in whatever decisions were taken by the government, I think the committee will be fully within its right to summon them. Now, exactly what happened, Vinod Sharma may be privy to that, but I think that kind of inference and that kind of position would actually privilege the proceedings of the JPC.
Okay,
Vinod,
we're completely running out of time.
After all, this is
Vinod, 1 second. There's no more time left. I just want you to give me the last words on this. Will Chidambaram be a more confident man after this?
Well, he gave a press conference today, and he looked pretty happy and buoyant. But then, the way...
What about the internal dynamics in the party as far as Chidambaram is concerned?
Well, Chidambaram is an important person. Otherwise, he wouldn't have been placed as finance minister.
Right.
Moved out of the home ministry and placed as finance minister, a position that was held by the man
his
who's elevated
position
as
has
president
become
now.
stronger now within the party.
You see, this is all a matter. This is all a subjective assessment.
Right.
But surely, for the time being, he's relieved, and he feels that he has got greater room to maneuver, and that he can maybe decide more freely on issues which are before him as finance minister.
Okay, I think we're completely run out of time. So it is interesting, but Dr. Swamy says that he will go back to the court for a review. We will wait and watch that. But as Vinod rightly pointed out just now, Mr. Chidambaram now will have that more leeway and more confidence to face not only his own ministry, take up work within his own ministry, but be a more confident man in the parliament, where he will have to face a lot of tough situations. Thank you very much. Thanks to all my guests. Thank you, Dr. Subramaniam Swamy, Mr. KTS Tulsi, Nilotpal Basu, and Vinod Sharma. Please keep watching. We'll come back with another issue on the big picture at the same time on Monday.